Think about a Renaissance oil painting. Now look at a corporate logo, skyscraper blueprints, or a glowing screen of Python code. Which of these creations is actually protected by copyright law? If you look at the legal framework, the answer is potentially all of them. We naturally link copyright to beauty, assuming it exists to guard artistic merit or emotional impact. But in reality, the law strictly ignores aesthetics. In Belgian law, aligned with the European courts, beauty is completely irrelevant. The entire system pivots on a single clinical standard, originality. To a judge, a messy string of software code is as legally sacred as a museum masterpiece, provided it meets that specific standard. The Court of Justice of the European Union serves as the ultimate authority here, unifying exactly what originality means across member states. In a 2009 case known as InfoPack, the court examined an extract of a news article that was exactly 11 words long. They ruled those 11 words could be protected by copyright. Legal experts map this threshold precisely. A work earns protection only if it is the intellectual creation of the author. The author achieves this by expressing their personality through free and creative choices, leaving a personal stamp on the work. But if protection requires free and creative choices, how can someone prove they left a personal stamp on a project defined by rigid technical rules, like a bridge or a database? To solve this, we can look at a spectrum of constraint. This visualizes exactly how much freedom a creator has, ranging from total artistic liberty to pure technical restriction. Let's start on the high freedom end with photography, guided by a famous case called Painter. Even when shooting a standard portrait, originality lives in the micro decisions. The photographer's free choices regarding framing, lighting, the angle of the lens, and the pose of the subject are what stamp their personality onto the image. Move slightly down the spectrum to commercial works, like corporate logos or industrial design. Do these require some elevated aesthetic value to earn protection? This chart tracking European law points to the Cofamel ruling, where the court explicitly banned national laws from demanding aesthetic value. The only criteria allowed is the presence of those free choices. Whether an image hangs in an art gallery or sits on a highway billboard, the law only searches for the presence of choices, not the presence of art. Slide all the way to the far right of the spectrum, we hit architectural blueprints and source code, creations heavily dictated by gravity, physics, and computational logic. The ultimate test of this boundary came in the Brompton case. The court had to decide where technical necessity ends and original creation begins for a highly functional folding bicycle. They established an absolute limit. If the shape or structure of a creation is 100% dictated by its technical function, there is zero creative freedom. Zero creative freedom means zero copyright protection. But there is a vital caveat. If, despite the heavy technical constraints, the architect or the coder retains even a tiny margin to organize, arrange, and design things their own way, their personal stamp survives. Heavy technical constraints do not automatically destroy copyright. They simply shrink the canvas. As long as a margin of choice remains, protection remains. Because originality relies entirely on uncovering these personal choices, courts can never evaluate creations in bulk. You cannot legally declare that all source code is protected or no commercial logos are protected. The legal filter must be applied specifically work by work. It is a forensic search for the author's individual margin of freedom within a project. If there is no margin for choice, there is no originality. Copyright is not a reward for beauty. It is simply the legal shadow of human choice. Note: this video is designed to provide general legal information and framework understanding and does not constitute formal legal advice.